can I make an announcement just a little bit about the December 6th?
Yeah, sure.
Yeah. So this is Vivek, and I'm one of the member at ANA. And so since December 6th is approaching, and there will be a lot of events throughout the United States, and across the world as well, I believe. But the unique thing about this event, Anna has been doing it, and Anna is also asking the other Ambedkarite in USA to run such a blood donation drive that's been going on for since pandemic we started, and I think all around the world, also wherever the Ambedkarite presence is there, they are doing it. So in each the city that you are living in, we asking the members, if they can enroll with the Red Cross Society and donate, for Baba. And if you need any flyers or anything, if you are trying to take pictures or anything, please do let us know. We'll send you the pictures, and we can publish in your local area. In Michigan, we are doing it on December 6th, where the members from Ambedkar community would be donating the blood on this occasion. So that's the one announcement I wanted to make. Thank you. Okay, back to you, Pranit.
Thanks. Does anyone has any question about this announcement, just in case? Okay, so we can move forward with our main guest speaker session. Um, our guest speaker today is Dr. Alka Patil, presenting on basic rights of the citizens in India and USA and a comparative study. I would like to provide a brief introduction about Dr. Patil. Dr. Patil served as an assistant professor of law at Swami Vivekananda Law College, Chembur in 2012. In September 2012, also, she had joined as an assistant professor of law at University of Mumbai, teaching a variety of subjects at Department of Law, University of Mumbai, including law and social transformation, Indian constitutional law, new challenges, judicial processes, legal education, research methodology, comparative constitutional law, administrative process, judicial control, national security, um, and many more. For example, protection, and enforcement of human rights in India, etc. Dr. Patil completed PhD in law with the concentration of constitutional philosophy of good governance and the role of Supreme Court in India. Dr. Patil have participated and made presentations, published articles on the topic, including constitutional law, administrative law, comparative studies of different constitution, social transformation, and legal responses. Also, relationship between rule of law and economic development. Um, in different parts of countries, and international conferences, seminar, courses, workshop in on variety of legal issues. Dr. Patil have been a member of various committees of the universities and member of professional bodies. Dr. Patil have been an invitee as guest speaker, resource person in various academic institute, and Dr. Patil have been a coordinator in refresher courses conducted by UGC HRDC at University of Mumbai. Please welcome Dr. Patil.
Thank you so much, Mihir. Am I audible?
Yes. Is it possible to increase the volume a little bit?
Uh, it's a full volume in my device. It is okay?
Yeah, I mean we can definitely hear you.
I shared my PPT to Vasnik sir or Samruddhi. Is it okay for to share?
Um, yeah, if you have your okay, go. Yes.
Yeah, Samruddhi. Yeah. Click one more, Samruddhi. So, first of all, Namo Buddhaya. Good morning to all joining from the United States, and a very good evening to everyone joining from India. It's a venerable member of the Sangha, Upasaka and Upasikas, and dear Dhamma friends, dear Dhamma practitioners, and respected guests and dear students. I would like to express my sincere gratitude to Anna for inviting me as a guest speaker to the online Buddha Vihar program. I deeply appreciate the opportunity extended to me. So, in this session today, I will be addressing the theme Basic Rights of the Citizen in India and USA, a comparative study. So, shall I begin with this second slide, please? So, my main point of this on the topic of is for the introduction, how it's the evolution of rights, the constitutional philosophy behind rights, structures and classification of rights, enforcement mechanism, and what are the main comparative themes, the main important landmark judgment, and the issues going on currently, and the conclusion. So the first, go for the next one, Samruddhi. The first is for the history of basic right. As everyone know, in India we have fundamental right. We know this words is very popular in Indian Constitution, whereas in the United States they call civil liberties, they call Bill of Rights. But I would like to touch in that point, which is for the grassroots level, for the beginning of this. So, history of basic rights in the USA began with the Declaration of Independence in 1776, which introduced the idea that all individuals possess natural rights such as life, liberty, and the pursuit of happiness. These ideas were later formalized in the United States Constitution 1787 and especially the Bill of Rights 1791, which guaranteed freedom like speech, religion, due process, and protection against arbitrary government powers. Over time, through amendment and Supreme Court decision, such as the 13th, 14th, 19th Amendment, and the Civil Rights Movement, the scope of this right expanded to include equality, voting rights, and protection against discrimination. Where in the basic of history of basic in India, which grew for the freedom or struggle, where leaders demanded civil liberties and protections against colonial rule, which inspiring the inclusion of rights in the constitution. When the Constitution of India came into force on 26 January 1950, the framer, Dr. B.R. Ambedkar, adopted a comprehensive list of fundamental rights to ensure equality, freedom, justice, and protection from state excess. Over time, through the constitutional amendment and landmark Supreme Court judgments, such as Vishaka, Keshwananda Bharti, Manika Gandhi, and these rights expanded in scope of nature, making them more enforceable and essential to Indian democracy. So, why we call fundamental rights in India and basic rights in the USA? In India, we are calling fundamental rights because the Constitution explicitly lists them as an essential guarantee that are fundamental to the life and liberty of every citizen. And they are directly enforceable by court under Article 12 to 35. These rights are written in a single organized chapter, which making them a structural constitutional guarantee. Whereas on the other hand, in the USA, the term basic rights often referred to as a civil liberties or constitutional rights is used because rights evolved from philosophical idea of natural rights and were later added to the constitutional through the Bill of Rights 1791. Unlike India's single chapter, American rights developed through amendments and Supreme Court interpretation. So they can commonly through amendment and Supreme Court interpretation. So they are commonly described as basic or fundamental liberties rather than given one formal name like in India. The next one. So which country play an important role in incorporating fundamental right in the Indian Constitution? In this chart, we came to know for the evolutions, key features, objective of fundamental rights, and 6 fundamental rights. While drafting the Indian Constitution, Dr. Babasaheb Ambedkar and the Constituent Assembly drew major inspiration for fundamental rights from the Constitution of the United States of America, especially the idea of a written Bill of Rights and judicial enforceability. The American model strongly influenced articles on equality, freedom, and protection against arbitrary state action, including the rights to constitutional remedies. Other countries such as Ireland, the Britain, the France were also studied, but the USA played the most important role, providing the core framework for individual liberties that Dr. B.R. Ambedkar incorporated into Indian's constitution. So, what are the objectives of fundamental right in India? The main, to ensure individual liberty. Fundamental rights aim to protect every person's freedom, such as speech, movement, religions, life, so that citizen can live without dignity, without fear of arbitrary action by the states. To promote equality and remove discrimination. These rights ensure that all citizens are treated equally before the law and are protected from discriminations based on religion, caste, sex, or place of birth, helping create a fair and just society. Then to strengthen democracy, the guaranteeing freedom and allowing citizens to challenging government and government action in court, which fundamental rights make democracy meaningful and participation. To protect human dignity. These rights uphold the core values of justice, fairness, and respect for every human being, which ensuring that no person is deprived of basic rights protection. To maintain balance between individual and state power, fundamental right act as a check on the government, which preventing misuse of authorities and maintaining a healthy balance between citizens' freedom and state responsibility. So the original fundamental rights which accepted in 1950 were 7 fundamental rights. Right to equality, then right to equality, right to freedom, right against exploitation, and so on. Right to equality, right to freedom, right to exploitation, rights of religions, culture, educations, and rights of constitutional remedy. Here, I would like to go little deep for right to equality part, because the thing is, everyone want to know that, yeah, these are my rights are going to be affected. They just want to go before a court of law and say, no, these are my rights, it's going to be affected with the Article 14. But it is not the way. Article 14 is simply provide you the equality before law and equal protection of law. There will be nothing you can be go and uphold Article 14. Whereas Article 15, you can say, I'm going to face on the basis of discrimination part, like on the basis of caste, on the basis of race. So Article 15 is important. Article 16, 17, 18 is important. But Article 14 provide only and only right to equality and nothing more than that. Article 14 what says? Equality before law and equal protection of law. But if you face any kind of your rights are going to be violated, you can be go to the other article. 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25 till 32. Now, post 44th Amendment 1978, which removed the right to property from the list of fundamental rights due to the frequent conflict between the public welfare laws and property claim. It was made a legal constitutional rights under Article 300A, capital A, not a fundamental right. So the originally Article 31 and Article 19(1)(f) were also a part of fundamental rights, but after the 44th Amendment, the right to property became a legal rights under Article 300 and 300 capital A. In this period, a very twist and very landmark case would happen. You might be aware that Indira Gandhi case, people will call Indira Gandhi case, people will say election case, people will say Raj Narayan. People will also call that's an emergency case. So that was the year is 1975, where in the 1971, the Lok Sabha election, Indira Gandhi contested for the Rae-Bareli constituency. Her opponent was Raj Narayan, a socialist leader known for his bold nature. And after Indira Gandhi won by a large margin, Raj Narayan believed that she had not won fairly. So he claimed she had used government machinery, government officers, and unfair methods during her election campaign. Sorry. So, which is prohibited by election law. Therefore, he filed an election petition in the Allahabad High Court in 1971. The case continued for almost 4 years. On 12th June 1975, Justice Jagmohan Lal Sinha of the Allahabad High Court gave a historic judgment. The court found that Indira Gandhi guilty of 2 electoral malpractices: using a government officer for election work and misusing state resources. So as a result, the court declared her 1971 election void, disqualified her for 6 years for contesting election, and technically she had to step down as the prime minister. So the Indira Gandhi immediately filed an appeal before the Supreme Court, which granted her a temporary stay. She could remain prime minister, but she could not vote in parliament just 13 days after the High Court judgment. So the immediately on 25th June 1975, Indira Gandhi declared a national emergency, claiming threats to national security. So under the emergency, many fundamental rights, especially the right to liberty, were suspended. Opposition leaders were arrested and press freedom was restricted. So after that, the government passed the 39 Constitutional Amendment 1975, and the amendment said that the Prime Minister's election could not be challenged in any court, and only a special body in Parliament could review it. This was widely seen as a way to protect Indira Gandhi's position. Later, when the case came before the Supreme Court, it upheld parts of the High Court judgment, but also allowed Indira Gandhi to continue due to her new amendment. So in 1977, after the emergency ended, new elections were held and the public rejected the emergency rule. Indira Gandhi lost her seat and the Janata Party came to power. The new government remove many emergencies era changes and restore democratic value. So the main is important of this case, the related to fundamental right, that this case is remembered as a powerful example of how the judiciary tried to protect free and fair elections and how political power can sometimes clash with constitutional principles. It shows the importance of judicial independence, electoral integrity, and fundamental right is a democracy. The second important in fundamental rights here, that is fundamental right enjoyed by only citizen and non-citizen in India? So the answer is both. Because in the Indian Constitution, some fundamental rights are given only to citizens, like equality of opportunity, freedom of speech, or protection against discrimination. But these rights relate to citizenship, national belonging, and democratic participation. But many other rights, such as rights to life and personal liberty, Article 21. Article 21 start from the protection, right to life is important to every individual, citizen, and non-citizen as well. Protection against exploitation and freedom of religion, which are given to all persons, including foreigners, because these rights are based on human dignity and apply to all human beings, not only to Indians. So, therefore, we can say that here fundamental rights are enjoyed by citizens as well as non citizens, depending on the nature of the rights, some as universal human rights, while other as citizenship based democratic right as well. The next one. Now, in US Constitution. What is US Constitution and the Bill of Rights? So, the US Constitution is the highest law of the United States, created in 1787, the oldest constitution in the whole world. Like we call Indian constitution is a lengthiest written constitution, bulky constitution in the whole world. The same in US Constitution is the highest law of the USA, created in 1787. It set up how the government works, dividing power between the President, Congress, and the Supreme Court, and protects basic freedoms. It is a short document that explains how the country is run and how people rights are protected. So the Bill of Rights is the first 10 amendment we added to the United States Constitution in 1791. It lists important rights and freedom such as freedom of speech, religion, fair, protection against unreasonable searches, protection against cruel punishment. These rights are meant to stop the government from misusing power and to protect individual liberty. Now, What were the first 10 amendment of the US Constitution? So number 1, that is for freedom of speech, religion, press, assembly, and the right to protect. Whereas the second, right to keep and bear arms. It's like weapon, regarding for the weapon. The third, government cannot force people to keep soldiers in their homes. The next is protection against unreasonable searches and seizures, which like police need a warrant. The next is for right to remain silent, fair trial, protection from being tried twice for the same crime. We generally in legal term we call double jeopardy. The next one is the right to a speedy and public trial. Then jury trial in civil servant, protection against excessive bail. People have more rights even if they are not listed in the constitution. And the 10th one is the power not given to the federal government belong to the state or the people. So the amendment is a formal revision or additional to the US Constitution. As per Article 5 of the Constitution, there are several methods to propose an amendment. So the once an amendment is proposed, it's required the approval of 1/3 of the state to be rectified. So here for the distinction between how the US Constitution, the main constitutional document, whereas the other is a Bill of Rights, which is protect individual freedom for the government. US Constitution has only 7 articles, whereas in Indian Constitution we have today 106 article in the Constitution. Go for the next one. So here the amendment. The amendment is a formal revision which traditionally states are free to rectify proposed amendments at their in the indefinite period of time. Like for example, the 27th amendment was not ratified by the necessary number of states until over 200 years after it was proposed, and modern amendment proposed tend to include a 7-year time frame for states to rectify an amendment. And for this reason, the Equal Rights Amendment has not become law despite achieving rectification by 3/4 of the states. So, as of now, November 2025, the United States Constitution has been amended 27 times, including the first 10 amendments, are known as the Bill of Rights. Now, this is the Constitution, Indian Constitution, that's the parts of Constitution, where everyone know part 3 is a fundamental right, part 4 is a directive principle of state policy, and part 4A is the fundamental duties. Basically, I'm every time simply say that when you say these are my rights, so instead of saying these are my rights, I'm just asking them, what are your duties? So a simple example, like when you're driving your car and scooty, you have to follow some rules like using helmet, using seat belt. These are your first duties. And if you are following your duties, automatically right applicables to you. So the rights and the duty is simultaneously going to be a together. It's like a parallel both two lines. When the fundamental right is concerned in India, we say start for the Magna Carta. fundamental right history in India, it starts for the Magna Carta. So the what is Magna Carta? Magna Carta is the Latin Great Charter. It was a document signed in 1215. It was the oldest document, first document, 1215 in England by King John. Under pressure from his baron, that it was the first major step in limiting the power of the monarchy and establishing the principle that everyone, including the rights, must follow the law. The guarantees certain rights like protection from illegal imprisonment, fair trial, and respect for property. We use the word Magna Carta in the history of fundamental rights because it is seen as the earliest foundation for modern human rights and civil liberties. Its idea influenced later documents such as the English Bill of Rights 1689, the US Constitution, and ultimately the fundamental rights in the Indian Constitution, particularly the concept of rule of law, personal liberty, and protection against arbitrary government action. We call Indian fundamental rights borrow from the USA and France because the farmer of the Indian Constitution studied 60 different other countries while drafting these rights. And from the USA, they adopted the idea of a written constitution with enforceable individual rights like equality, freedom of speech, and protection against arbitrary government action. From France, they were inspired by the Declaration of the Rights of Man and Citizen 1789, which emphasized liberty, equality, and fraternity. By combining these ideas, Dr. Babasaheb Ambedkar and the Constituent Assembly created a set of fundamental rights that protects citizens' freedoms and promote justice in India. So this is the journey of fundamental rights. How we can incorporate in fundamental rights. We do agree, we accepted that our constitution has borrowed, so Ireland, Canada, Australia, USA, even UK as well. We should be remember that UK has unwritten constitution. Despite unwritten constitution, we say we borrow from the UK constitution in our Indian constitution. Some of the things are written, but it's called as unwritten. The same is vice versa. We could not completely 100% say that it is a copy paste from the different constitution in our constitution. We accept it as per our population. We expect it as per our developing country. We accept it as our customs and traditions so that in future, Indian citizen will not affect any articles which incorporated in the constitution. The next one. So these are the main structure and classification of rights where, as I mentioned, the fundamental rights into 6 groups in part 3 of the constitution, where in the US constitution it's called the individual liberty and first an amendment which known as the Bill of Rights. Document also, we cover that part. Enforcement as well. The limitation is important. So limitations are provided on this structure and classification of rights in the USA and India to balance individual freedom with the needs of society and the states. Absolute rights without limit could create chaos, could create conflicts, or harm public order, security, and the right of others. In India, in fundamental rights like freedom of speech and expression, which is Article 19, Article 19 has given you full fledged freedom of speech and expression. But in Article 19.2, it's restricted in the interest of sovereignty, security, public order, decency, or morality. Similarly, in the USA, rights such as free speech or the right to bear arms have legal limit to prevent harm or maintain law and order. These limitations ensure that rights are enjoyed responsibly while maintaining a stable and fair society. The next slide, please. Yeah. The here in the important part for the social economic rights. So in India, social economic rights are considered part of the directive principle of state policy, DPSP, under Article 36 to 51 of the Constitution, rather than fundamental rights. These includes right related to work, education, health, social welfare, and equitable distribution of resources. While they are not directly enforceable in court, they guide the government to make laws and policies aimed at reducing inequality, poverty, and social injustice. Whereas, in contrast, in the USA, socio-economic rights like the right to education, healthcare, or social security are generally not included as enforceable constitutional right. The US Constitution focused mainly on civil and political liberties. However, various social welfare programs which have been enacted by Congress to provide economic securities, but these are policy measures, not fundamental legal rights. So the India formally recognized socio-economic justice in its constitution, while the US relies more on legislation and government programs to achieve similar goal. The the philosophy of basic rights in the USA is rooted in the idea of natural rights, meaning here that every person is born with certain freedoms like life, liberty, and equality that the government must not interfere with. These thinking came from philosopher uh, like John Locke and influenced the US Constitution and the Bill of Rights, which focuses mainly on protecting individual from the government by limiting state powers. In contrast, the philosophy of fundamental right in India is broader and combine both natural rights and social justice. Indian constitution guarantees classical freedom like equality and liberty, but also emphasize that the state must play a positive role in reducing poverty, removing centers removing discriminations, and protecting vulnerable groups. While the USA's rights philosophy centers on individual freedom and limiting government. So the Indian philosophy, which is balance individual liberty with social welfare, which is aiming to protect and create a equal, legal, and inclusive society. So in India, socio-economic rights form a central part of the constitution vision for social justice, and they are mainly included in the directive principle of state policy under Article 36 to 51. These rights focus on improving the lives of people through access to education, healthcare, livelihood, minimum wages, human working conditions, equal distribution of wealth, protection of children and women, and the promotion of social welfare. Directive principles are not legally enforceable in court. They guided they guide the government to make the policy that reduce poverty and inequality. Over time, Indian courts have expanded the meaning of Article 21, that is right to life, which includes socio-economic elements like right to education, right to livelihood, right to shelter, and health, making many of these rights practically enforceable. Whereas, on the other hand, in the USA, the Constitution does not formally recognize socio-economic rights as fundamental, enforceable rights. The US Bill of Rights focuses mainly on civil and political rights, which I mentioned earlier, such as freedom of speech, fair trial, protection from government overreact, social, all this stuff. So, socio-economic rights like the right to health, education, or housing are not guaranteed by the Constitution. Instead, such protection came from government programs and legislation. So, the social securities, Medicare, public schools, welfare assistance, and labor law. These are the policy choices, not constitutional rights. Courts in the USA generally do not force the government to provide socio-economic benefit as a matter of right. So, in India, embeds socio-economic rights in its constitutional philosophy to build an equal and welfare oriented society, while the USA protect mainly individual freedoms and rely on legislation, not constitutional guarantee, to provide socio-economic support. Judicial role in the USA and in India, whereas in judicial role in the USA primarily focused on protecting individual rights and limiting government power through judicial review, which is the main famous doctrine um, established by the landmark case Marbury versus Medicine, 1803. The Supreme Court in US is highly independent and often play the role of a constitutional watchdog, striking down laws that violates the Bill of Rights or the basic structure of the Constitution. Its decision strongly shaped American politics, civil liberties, and social policies because constitutional interpretation in the USA relies heavily on precedents and the idea of limited government. Where in India, the judiciary play a much broader and more active role. In Indian Supreme Court, not only protect fundamental rights through judicial review, but also act as a guardian of social justice. which expanding rights through creative interpretation of the Constitution. There are so many landmark judgments which have turned into socio-economic needs, such as education, health, clean environment, and many more, which is enforceable rights under Article 21 of Indian Constitution. So the main distinction here that in India, it's little bit we have more rights to go before the court of law compared to the US. In history of aim of the rights in the USA was to limit government power and protect individual liberty. The American constitutions and the Bill of Rights emerged after the struggle against British colonial rule. So the founders wanted to prevent any form of tyranny where their focus was so securing personal freedom, such as freedom of speech, religion, property, and so on. The judiciary in the USA was designed to act as a check on the legislature and executive, which ensuring that no law or action violates these protected liberty. The American approach is rooted in liberal philosophy, individualism, and natural rights theory, which is inspired by the John Locke. And in India, we have Article 21, we have a public interest litigation tool, so we can go directly before the court of law. So India's aim is transformative constitutionalism, using law and rights to create a more equal, fair, and democratic society. The next one. These are some main the power, the governing rights, constitutional protection of rights, foundation constitutions, then philosophical foundation of rights, then equality jurisprudence. So there are main different type of jurisdiction here, where we came to know that India has much more deeper, wider, like provide of social, political, and economic relation. Even India has the basic structure of doctrine where through the Keshwananda Bharati case that parliament cannot destroy the core value of the constitution, such as democracy, secularism, separation of power, judicial review, and fundamental rights. Where if we consider in the USA, it is like little, uh, it's a classical liberal constitutional philosophy, which focuses primarily on individual liberty, limited government, and protection from state interference. And this Marbury versus Medicine case 1803 is more established the concept of judicial review. The judicial power act as a strong check or government. Equality jurisprudence is also important in USA and India, where equal protection of the law in USA 14th amendments provide prohibited states from denying equal protection of the law. American equality jurisprudence focus on preventing discrimination by the government based on race, gender, or other suspect classification. And the US court uses the three-tier security system. So the three-tier means strict security scrutiny, the race, religion, national origin, which is very, very tough test. State usually loses for that. The second is for intermediate scrutiny, which is for gender discrimination. And third is for the rational basis test. So these are the main important concept here in India and USA. Whereas India, we have Article 14, equality before law, Article 15, discrimination, Article 16, opportunity. Then even we have the affirmative action, which is for the reservation. Reasonable classification also provided in India, arbitrariness doctrine. So in rights enforceable enforcement in the USA is shaped mainly by the judicial review power under Marbury versus Medicine case and the Bill of Rights plus 14th Amendment. US code enforce rights through strong court center doctrine, which I mentioned it is for the strict scrutiny, intermediate, rational, plus state action doctrine. Constitutional rights are enforced only against the government, not private individual, except in limited cases. Same in substantive due process. Court protect fundamental right, privacy, marriage, even if not explicitly written in the constitution. So overall, we can say the Indian US model is court driven, liberal individualistic, and based on limiting state power. Where in India has broader, more expensive, flexible, and social justice oriented. Because we have two important articles, that is Article 32 and Article 226, Supreme Court and High Court. Every person can move before the court of law and file a complaint, even if the person is belongs to a poor family, legal service authority, then Lokpal. There are so many things in India. The next one. So, in the constitutional philosophy behind rights, we came to know here for the due process because origin we the point is covered. The focus is also then judicial review. The due process concept in India it's came from USA. The due process which allow court to evaluate not just whether a procedure was followed, but also the fundamental fairness and justness of the law. Whereas in Article 21 in the Indian Constitution, where specifically mentioned, no person shall be deprived of his life and personal liberty except procedure established by law, which is meaning the judiciary primarily ensure that laws are followed rather than evaluating the fairness of the law. And itself, its through of interpretation has broadened. Even its concept came from USA, due process of law. But in India, it is not defined as well. It is pronounced by the Supreme Court and High Court on the basis of the case, on the basis of the facts and circumstances. The next slide. Now, the basic structure of the doctrine. These are the some landmark cases in India where Sajjan Prasad case 1951 after the Constitution of India accepted in the 1950. It is absolute power to Parliament in amending Constitution. I would like to explain here for the absolute thing because this absolute power in USA is present. Absolute thing means that if a single, for example, a single coin, we can say it is a black and white coin. We consider it is a black and white coin. If we want to, that black will cover or will change in gray, that definition is not come in that ambit. So absolute means you cannot change. It is a fix. It's not ups and down, left and right. So In Indian constitution, we cannot say we have an absolute thing. It is a flexible. Whereas in US is a rigid and absolute thing. That is why it is some of the rights and some of the things very difficult to change and modify in US constitution. Keshwananda Bharati case has a main new doctrine of basic structure where it's defined even in the changing in the Indian constitution by way of amendment. We cannot touch the basic structure of the constitution. And Indira Gandhi case, which I mentioned in the very beginning, that it is a reaffirmative of doctrine of basic structure in Indian constitution. The next one. Yeah, these are the some function which everyone I think it's no for the democracy. If the democracies we call that, for example, this country has full of kind of democracy, then we provide free and fair election, citizen participation, respect for rule of law, judicial independence, and so on. So this is only for the definition here. Some concept that even though we have a unitary system, federal system, and so on, but authority play a major role to accept it. Like in India, we have 106 articles. Despite the article, we have three different lists: union, state, and concurrent list. Whereas in USA has only one single list and a specific subjects over there, and the specific subjects are defined. Specific subjects are absolute. So you cannot change. So you cannot modify as well. So the thing is, because of that, it is a rigid in US Constitution. The next one. So the United States here, we cover the point of Bill of Rights, we cover the written constitution, preamble, of course, preamble has the different history. In US constitutions call for we the people of United States, and India, we call we the people of India in our preamble. The we has its own history. So this is like why we is included in Indian constitution. The reason is at the time of draft preparing the Indian Constitution, Dr. Baba Sahib Ambedkar, when they started the making a preamble, people will belongs to different community. They call, we can use the word, like if I am following Jesus, I could mention that Jesus is the people of citizen. Like if I belongs to a Mohammedan, I say Mohammedan is the so and so. So Dr. Baba Sahib Ambedkar is the first person he mentioned. Why we not use the word we? So in that WEV, it's entire the member in the parliament has do agree for that point. And now today we are using the word we. This is the one of the small history of why we are using we, the people of Indian, in our preamble. In this point, the main important for the impeachment of the president. US impeachment of the president in the United States has two steps. Like first, impeachment by the House of Representative, like filing charges, and trial and removal by the Senate, which require a two-third majority. Grounds for impeachments are bribery or other high crimes and misdemeanors. So the House Judiciary Committee investigate and drafted article of article of impeachment. The House votes by simple majority to impeach, but the Senate conduct a trial presided over by the Chief Justice only when the president is on trial, and conviction and removal required two-third Senate majority. No US president has ever been removed from office though some were impeached. The example of Andrew Johnson, Bill Clinton, Donald Trump twice. So, the impeachment of the president in India, impeachment is also a parliament process, but the ground or procedure are more strict and detailed. So, the president of India can be impeached only on one ground, that is violation of the constitution, Article 61. And the process is the same like either House of Parliament. One fourth of the total member house must notice and sign, and the notice must be given 14 days in advance. The house then investigates the charges, and often through a special committee. After investigation, the house votes on the resolution that two-third majority of the total membership of that house, and not just through present and voting. So after that, two-third majority of total membership, the both houses agree the president is removed from office, and no president of India has ever been impeached. This is the USA and the India specifically for the impeachment. The next one. So just that point we cover, that two-third of the Senate is removed is important, and there is no specific such rule in India for the role of Chief Justice, where in USA is a preside over of Senate trial, and the ground is which I means violation of the constitutional right. And this is a who started. The both houses started in India, either or out, whereas USA is a house of representative. So these are the definition of how it's going to be processed for the impeachment. The next one. Yeah, this is a little important case, like in landmark case in Supreme Court in India Constitution, which I mentioned is 1951, after Constitution accepted Champaken Donai Rajan case, and the next one is Golaknath, then Keshwananda Bharati, and then Minerval Mill case. So the first one is landmark in India, that is Keshwananda Bharati. Because Keshwananda Bharati case in India, whereas in USA is the Marbury versus medicine. So what was the Keshwananda Bharati case? What happened in that case? Keshwananda Bharati, a Hindu from Kerala, challenged the government's land reform, arguing they violated his fundamental right. And there were issue whether the parliament has limited power to amend the constitution, including fundamental right. So what did the Supreme Court decide? The parliament can amend any part of the constitution, but it cannot destroy or change the basic structure of the constitution. This became the basic structure doctrine, the most important principle in Indian constitutional law. What is basic structure? That supremacy of the constitution, rule of law, judicial review, federalism, secularism, separation of power, fundamental right, democracy. So the importance of this case of Keshwananda Bharati to ensure that no government can misuse power to destroy democracy rights or judicial independence. To protect Indians' transformative social justice, which is based on constitution. Whereas Marbury versus Medicine in the US case, where William Marbury was appointed by outgoing president John Adams, new president Thomas Jefferson blocked the appointment. Marbury went to the Supreme Court seeking an order. The issue was whether the Supreme Court has the power to declare a law passed by Congress unconstitutional. So, what did the Supreme Court decide? Chief Justice John Marshall held that the Constitution is the supreme law. Courts has the power to interpret the Constitution. If a law violates the Constitution, the court can strike it down. This create the doctrine of judicial review in the USA. And what is the importance of the case is it made the Supreme Court, US Supreme Court, the guardian of the Constitution, ensuring the government stay with constitutional limits. So the main question here, can Parliament amend Constitution without limit? In Keshwananda Bharti, whereas in Marbury versus Medicine US case, can the court strike down unconstitutional law? Where in India, its question is for the basic structural doctrine, whereas for the Marbury case is judicial review doctrine. And what are the goal of these two? In India, protect democracy from parliamentary overreact, whereas in USA, limit government power and protect the constitution. Whereas in India, the case of parliament cannot destroy core value, whereas in Marbury US case, the court became the supreme interpreter of the constitution. So the in India, the transformative and social justice oriented, where in USA is a classical liberal and limited government. The next case is Maneka Gandhi versus Union of India. That case is the Indian government seized Maneka Gandhi's passport without giving a reason. That she approaches the Supreme Court claiming that the violation violated her fundamental right. And the main issue is here the meaning of just I explain Article 21, procedure established by law. Is any procedure enough or must it be fair? The Supreme Court expanded Article 21 and held that the procedure must be just, fair, and reasonable and not arbitrary. So the Article 21 must be read together with Article 40. As I mentioned, Article 14 never ever go before the court of law is a simple Article 14. It must be Article 21, 19, 15, and 16. So the Article 14, Article 15, and Article 19. And this case changed the Constitution into a living document, expanding rights. Right to travel, right to privacy, right to dignity, right to legal affairs, legal fairness must be important. So this case, Maneka Gandhi case, it transformed Indian constitution law by creating the golden triangle. Golden triangle means three articles, 14, 19, and 21, making fundamental rights broad, flexible, and people-centered. Where in USA case, Brown versus Brown, in this case happened, in the USA, schools were segregated white students in separate school, black students in separate school. So the case challenged racial segregations in public schools. The main issue was, does racial segregations in schools violate the Equal Protection Clause of the 14th Amendment? The Supreme Court decision, the court held that separate is inherently unequal. Racial segregations harms dignity, education, and equal access. Public school must be desegregated. And the importance of this case is it's ended legalized racial segregations, overturning one of the Plessy case in 1896. Yeah, which became the foundation for the American civil rights movement, strengthening the idea that equality includes dignity and not discrimination. So in the this thing, like when we compare for the Maneka Gandhi case and Bronze versus Bronze, Maneka Gandhi is directly under Article 21, whereas Brown versus Broad article, it is under equality under 14th Amendment, where expansion of right is a fairness plus reasonable doctrine, whereas US case is substantive racial equality. In Maneka Gandhi case, more focused on preventing arbitrary state action, wherein in Brown's case, substantive ending racial segregations, which is impact in Maneka Gandhi birth of Golden Triangle 1499-21, whereas Brown case is Civil Rights Movement Foundation. The nature of Maneka Gandhi is a procedure fairness plus dignity, whereas in Brown's case is equality plus dignity plus anti-discrimination. Whereas the constitutional philosophy of your both this case, Maneka Gandhi is for a transformative living constitution, whereas the Brown case is equality-based liberal constitutionalism. And the last case is Puttaswamy. This is the Puttaswamy case we compare to the Brandenburg. Puttaswamy case, in this case, what happened? Retired Justice Puttaswamy challenged the Aadhaar scheme. Nowadays, everyone has the Aadhaar card. I think in airport also, it is a valid document for the checking the name and everything, the address and all. So the retired Justice Puttaswamy challenged the Aadhaar scheme, arguing that collecting personal data without strong safeguard, which is violate the right to privacy. Because when you scan in finger and your thumb, it's going to be a main, the main, we can say in the main computer, every person's data. So if the computer hack, every data will go one is to another one. And nowadays, everyone knows it's going to be cyber crime and all. So this was the first case go before the court of law in 2017. The main issue is the right to privacy, a fundamental right under the Indian Constitution. The Supreme Court mentioned historic decision that, and that time it's a nine judges bench unanimously held that right to privacy is a fundamental right. Part of Article 21, right to life and personal liberty. Privacy includes personal autonomy, bodily integrated, data protection, and sexuality, food choices, etc. So the government can restrict privacy. There is a valid law. It serves a legitimate state interest. It is a proportionate and important of to form the foundation of data protection law in India. Whereas in Vandenberg case in USA, in here a Ku Klux Klan member, there is it's a name of Ku Klux Klan member. It's a Clarence Benbergum gave a speech containing racist and violent statement. He was convicted under a Ohio law prohibition, advocating violences. And the main issue, does the First Amendment protect speech that is offensive or violent in nature? The Supreme Court decision, the court create the imminent lawless action test, which is called speech can be punished. Speech can be punished only if it is a directed to inciting immediately illegal action and likely to produce such action. Means hate speech, offensive speech, or abstract advocacy in protected. So only direct incitement to immediate violation is unprotected. And in this case, important of that, strongest protection of freedom of speech in the world that limit government power to restrict political and unpopular speech. Forms the foundation of modern First Amendment jurisprudence. So where Puttaswamy case is more focused for the privacy, Bandersbeck case is more focused for the free speech, First Amendment. Court focus for the protecting dignity plus autonomy, where here case is protecting political and offensive speech. Where here more test of proportionality test, where he is for the eminent lawless action test. Whereas Puttaswamy case is transformative social justice orientation, where here is for the classical liberal uh, plus individual freedom, where here is for the privacy is a fundamental right, where here is the for the speech protected even if radical or offensive. So this is the case where we comparatively call, yeah, these two are different to contingency, but still there are few cases are it's gone to be a together one, and we face some of the things in the problem. The next one. So these are the some points which today are clear, like fundamental rights is emergency is important, judiciary how we adapted fundamental rights and basic rights in USA and India. So my conclusion in this today's session that the comparative study of basic rights in India and the United States, which revealed how two great democracies safeguard individual liberty through distinct constitutional philosophy. While the US Bill of Rights allow an absolutistic approach rooted in natural rights theory, whereas in India's fundamental rights adopted adopt a balanced model that harmonies individual freedoms with social justice. Judicial interpretation in both nations has played a transformative role in expanding the scope and meaning of these rights. Despite structure, historical differences, both systems affirms the certainty of human dignity, democracy, participation. Together, they offer valuable rights, insight into how constitutional design can protect citizens while responding to evolving societal needs. So, with this, I'm going to end of this the session. So, across the continent and the time zone, it is wonderful to be connected together today. So, thank you so much to all of you and the entire team of ANA. The Pranit, who is for the very beginning for maintaining the session, and Kranti Madam, you are good handling the all, the students' encouragement, motivation, and all this. So thank you, your entire team. Thank you so much.
Thank
Thank you,
you.
madam.
Thank you, Dr. Patil. Um, Definitely it has, okay, let me just do this. I'm just waiting for you to stop sharing and then we'll be good. Okay, great. Thank you, Dr. Patil. Apparently, it has been an overwhelming topic and most important one. Now, I would like to open the space for attendees to ask questions. If you have any questions, please raise your hand and then you will go one by one so that everyone gets the opportunity to ask the questions. Yes, Devang, as you unmuted first, please feel free to ask question.
I just wanted to thank you, Alka, madam, for a wonderful lecture. Hello, am I audible?
Yeah, but little low.
I, hello. Wait a minute. I just wanted to thank you, Alka, madam, for this wonderful lecture. Hello, am I audible?
Yeah.
Thank you so much, Devan. Thank you so much.
I just wanted to thank you, Alka, madam, for this wonderful lecture.
Yeah. Thank you so much, Devan. Thank you.
Okay. Mr. Satyanath, please go ahead and ask question. Thanks.
Yeah, I just feel that no matter what's written in the Constitution anywhere, it all depends upon the personal, political, philosophical thinking of individual judges. They can twist it and come up with any kind of judgment that suits their moorings, these personal, political, philosophical, cultural mooring. And that's evident everywhere. I mean, in India as well as in America. I don't know about other countries. Don't you feel that?
Um, if I'm not wrong, you're asking question about the different countries that different judges pronouncing their judgment. Am I right, Mr. Satynath sir? This was your question, if I'm not wrong.
Well, I'm saying that the same constitution can be
Mm-hmm.
interpreted entirely different ways depending upon the judges. I mean, it's most of the time constitutional matters are decided by a number of judges. So always there is a split. Majority opinion is this, minority opinion is this. And on some occasions they may be unanimous, but mostly they are split, and split along the ideological thinking, ideological wall separating them, the ideological, personal, cultural, political moorings of these judges.
Sir, if I get your point, but I'm not personally 100% agree with your point that if the case is go before the court of law, it is the judiciary, whosoever it may be, is a judge. He has to verify about the fact and circumstances. Like the document, like the book has given you the procedure that you have to be follow the procedure. But some of the thing when you are going before the court of law, the practicing is a different aspect. So if you are the focus of fully for the judiciary, that judiciary has not to fully pronounced, they are not doing their job, or they are going to spread some of the things. It may be possible. Yeah, there is some exceptional cases where it it's already happened, but in maximum cases, I don't think so. Even it will take time for the passing the judgment, and like especially for the civil cases in India, it's required like 10 years, 12 years, whatever it may be. But I don't think so the judiciary has fully is providing judgment on the basis of discrimination.
What is the percentage of cases where things are decided unanimously?
Sir, I think, yeah, this question, any one of my students who are present over here for the research scholar, if you have, you can just put the question of this, because I am the professor, I am not handling the cases before the court of law. But yeah, it's a pending lot of cases before the court. Due to that reason, expedites court, Lokpal, then Lok Adalat is also set up after maybe 2 months or 3 months. So sort out the cases as soon as possible. This kind of thing is going on in Mumbai High Court specifically.
No, I think you didn't. Sorry, you didn't
I
quite
could not hear you, sir.
follow the
I could not hear you.
thrust of my question. Is that seldom any course is any issue is decided unanimously. Okay, so given that when there is split in the decision making, some judges are giving this judgment, some are opposed. Isn't it true that they are deciding it on the basis of their personal, their cultural, their political moorings? If they are liberal, they give they give this kind of judgment. If they are conservative, they give the other kind of judgment. So it doesn't really matter what's in the constitution or what's in the law.
Sir, if I could not hear you properly because his voice are consistently breaking.
Satyanath ji, if
So
you, sorry, Dr. Patil, to cut you.
yeah, no.
Doc,
Pranit, I could not hear his voice. What he say? I mean, it's breaking. So
yeah, no worries, it happens, it's absolutely fine.
Di-
Satyanath ji, meanwhile, if you want to write it down in the chat box, that would be
yeah,
awesome.
that will be the fine
And
one. Yes,
we
yes.
can move forward with another question, and also we'll get back to your question as you write it down in the chat. Is that okay?
Mhm.
I think that's a good solution.
Yeah.
Okay, next, I can say, Mr. Bhagavat, if you can unmute yourself and ask the question. Thanks. Mr. Bhagavat, are you there? Okay, I think Mr. Bhagavat is not there, or maybe if he's here, he can definitely raise his hand again. Does anyone has any other question for Dr. Patil?
Yeah, now I could unmute myself. Sorry, I
Okay.
was struggling with my phone.
Absolutely fine. Go ahead.
I'm sorry. I'm very sorry.
You're fine.
All right. Madam, thank you very much for all the insight which you have given.
Thank you, sir.
My question will be very, very basic. Okay. And it will be a question which will be coming out from a very common man of our country. Okay. So the question is that despite our Indian constitution, which is one of the greatest constitution ever produced, why the Bahujan Samaj and the minorities are suffering more and more the more we go ahead. Maybe one of the reason we can say is that the constitution is not been implemented with the spirit and the value it was created. What can be done for this? What solution do you offer for this?
Yeah, I do agree with your point that people are suffering, especially because this community. But as a professor, I always tell to everyone, you should be first follow yourself. I mean, you are going to suffer. You know that the situation is there. Nowadays, everyone have technology. So you can put anything like, chat GPT, AI, you get a matter, you get a solution. But if your right, for example, your rights is going to be infringed, is going to be violated, you are going to be for court of law. But instead of that, if you are following your duty very sincere, there is no need. Why you are giving to chance to the other? They can use it. They can use your advantage. They can take your advantage. The number one thing. Second thing, that especially for this community, they are easily rely to the people who will get advantage. So before taking any decision, whatever, like as you mentioned, they are suffering. So suffering means there are so many kind of suffering. Which kind of suffering? The property is suffering, like in the environment, in for the appointment, any kind of thing. We do have options nowadays. RTI is the one thing. Right to Information Act 2005. When you can put 1 5 rupees application, sorry, before the any kind of institution, you will get a matter, you will get easily information of concerned person's knowledge, whatever it may be. But my again question is that we are normal people. Like, see, we are normal people. We are not have much more time, energy, money So we can go before a court of law and we can fight. And after some time, we can say, my PA, oh, you can go and handle the case. I will stay at home. Not like that. So you should be take a very straightforward decision. Why the other community has not suffering? Because we are not taking advantage of them. They are very smart. So nowadays, which I personally think that our community, especially for the yours mentioned, that community must be a very smart one. Even the people belong to a poor family, the village as well. People are using smartphone instead of using any kind of the negative, the thing, there is no use. You can use the positive thing as well. You are going to suffer, check on Google. English, Hindi, Marathi, every language uses there. So instead of blaming to the other one, of course, there are some, we cannot say that everyone is like, that it's completely that community is safe and they are not doing any kind of wrong and still they are facing the problem. It is not like that. They are still facing the problem, but don't try to react immediately. Just try to understand the thing. How can we sort out the matter? I'll give one example. I'm not sure whether this is the correct platform where I explain or not. One of my student, she is expert in the divorce case. So I say, how could you handle the divorce case when every time women's and the husband and wives are going to be fighting and all this stuff? So she can explain that, madam, there is special community, a lower class community. Their divorce case are much more high compared to the higher class people. So that one sentence when she put, I say, what are the reason? So she said, ma'am, the rich class, the people, the higher class, they are trying to manage, they're trying to settlement. Even there will be dispute, even they are facing the problem, they're trying to settlement. Lower caste people say, oh, you're not okay. I'll try to put the case of law before the court, and we are just trying to pay. Starting for the beginning, 1 month, 2 months, it's okay. But gradually your mind will silent, the stable. You will be regret. Arey, why we are facing the problem? There is the another way we can go it. There is a different way. So, which is the thing I personally feel every time we are going to court of law, we are trying to fire, we are saying we are suffering. No, of course we are going to suffer is one point of line, but we just try to focus for the way. If there is a problem, there must be a solution.
Okay. Okay, ma'am. Thank you very much. Maybe uh, my question was on the ground of social and an economic equality, which Baba Sahab, Dr. Ambedkar, and the Constitution Committee has envisaged. My basic question was, like, the Constitution is to ensure that the parliamentary democracy works, and the
Yeah.
democracy works, or the democracy is can be said working better only
Yes.
when the people of India, we the people
Yes.
of India, get social
Yes.
and economic equality. And the
Yeah.
social, and we the people of India are not getting social and economical equality. So
Yeah.
in that way, we can say, or the common man can say, that the democracy is not working, even though we have the
Yeah, we
constitution.
do. We do. Yeah, we do agree. Even when you, I mean, I don't know whether you're aware or not. Last speech by Dr. B.R. Ambedkar, he mentioned that constitution is good, but if the running people is depend on the running people, how the constitution is work. So that kind of thing. I could not get the exact the word of Dr. Baba Sahib had mentioned, but he
Yeah,
said
he
that the
said that.
constitution, yeah, the
He
constitution is
said.
super good, but depend on the person that how it's handle the government, and it's a vice versa. Even the constitution is not good and the people is good, the government is run very smoothly. The same thing. I do agree with you, Bhagat sir.
All right. Now I will just pause and I will let other members ask their questions. It's a very big debate and discussion. Thank you very much, Madam. And
Thank
Praneeth,
you so
please
much,
carry
sir.
on. Thank you very much.
Thank you, Mr. Bhagwan.
Uh, can I ask the question to Madam, Dr. Alka, Madam? I'm Hemant here.
Yeah,
Oh yeah,
yeah,
please go
Hemant.
ahead. Thank you.
First of all, good evening, ma'am. Ma'am,
Yeah,
my
good evening.
concern here is about the judicial appointment. Like, should national judicial appointment should be there, because it is one of the most important aspects in today's time. Because
Yeah,
totally Supreme Court and High Court is in control of appointment of judges. We don't know
do
what is
agree.
happening out there. So, National Judicial Appointment Commission or committee should be brought into the place, as per
Yeah,
your opinion, ma'am.
yes, because which I came to know, even if like your parent is judge, it will be easy to become a judge to you. It will be become a judge to your kids as well. So this kind
That
of
is the reason,
scenario is
ma'am. That is
going
the
on.
reason. Correct.
Yeah, that is the reason. Yeah, so it is, of course, it's a big thing. Even I personally think that there must be some accountability and transparency is required for the transfer of judges, appointment of judges in India, to be very frankly, Hemant, in this case.
Okay, ma'am. Thank you so much. Thank you so much, ma'am. Thank you.
Thank
Thank you
you.
for your like, and thank you for conducting such a good webinar, ma'am. Thank you.
It's thankful to the Anna team who has given me the opportunity over here. So thank you, Anna, as well.
I really do not want to avoid this answer in the chat before we move on to our next question. So to answer Satinath's question, Pramila has said, actually, there have been judges in India who have taken a liberal and independent approach, uh, uninfluenced by politics. Some of the most respected among them are Justice D.Y. Chandrachud, Justice P.N. Bhagwati, and Justice Abhay Oka. There are many more who have constantly given decisions by strictly upholding the Constitution.
Yeah.
If you would like to add anything, Dr. Patil, most welcome to do that. If you want to move forward with next question, we can also do that.
No, I will move forward the next one.
Okay. Sorry, Satyanaji, I would like to open this. I really do not want to make it as a discussion panel at this time because we want to be very mindful of the timing. If okay, we can give the opportunity to Mr. Vivek Chavan. Please go ahead. Thanks.
Hello, Jai Bhim. This is Vivek, and thank you,
Jai
Dr.
Bhim, sir.
Patil, for coming to this session and conducting such a advanced level, educational class to the world audience. Of course, and as you said, pretty, you know, nice way that the Indian Constitution foremost the best in the world, which we agree to that. However, we see time and again, the judges, the judgment. And I don't know, you are in academics, so you probably would have more knowledge than we do, as a lay people. But we as a lay people, when we read certain judgments given in the courts, be it a matter of a reservation or maybe the matter of a equality and so whatnot. Time and again, we have seen there are judges, giving judgment based on their own personal beliefs, which is fundamentally rooted in their religious practices. Uh, how do we see that when evaluating, you are taking a shelter of a constitution, when the judges judgments are given based on what you are interpreting, how the judge should interpret the judgment, given all the facts, and everything. Eight, we see there are wrong judgments given by the people because they are end of the they are individuals. Are there corrections made to these such judgments? By the, if it is made done in the Supreme Court, who is above them to decide and look back to that case again and review such petitions, and correct it? Are there any provisions? And the second thing, are there any contempts when they do such, give the wrong decisions? Are there any repercussions towards the judges? That's my question.
Um, Sir, thank you for asking this question, Vivek sir. Basically, that the sequence in India, like district court case, then high court, then it goes to Supreme Court. So yes, there is the power in the Supreme Court that is for the judicial review and for the petition. The caveat emptor is one of the thing that within the stipulated time you have to file the case before the concerned court. If there is error of jurisdiction, if there is error of fact and circumstances, you can put the same judgment order before the court that these are the error, and then it's going to be a review. It's called for the judicial review. There are two, three things in the court: the judicial review, judicial activism, and judicial transparency, accountability, where the court has reviewed the case and passed the judgment.
Okay, thank you. And the other question, I know when you say like, there was a judge from South India, who was jailed for bringing the corruption cases against the judges.
Yeah. Justice
Mhm.
Karnan.
Yeah, Justice Khanna. Yeah. So,
Mhm.
though he was right, but he was still prosecuted, by his peer judges, those who was raising the voices. So, are there any? I'm just, this is just a open conversation. I'm just trying to
Mhm.
understand, when we are talking
Mhm.
about the law and the
Mhm.
constitution, how does it fare, how, it doesn't make any
Uh,
sense, when it's not, we say the Indian constitution is far better, we talk all this liberty, equality, but it
mhm.
doesn't, it's not a functional, it doesn't appear to be a functional document, because
Uh,
every judges are interpreting in
mhm.
their own ways, using
Mhm.
their might, to
Mhm.
subjugate the weakers in the process.
Um, I will here mention one of the professor. That's the name of Professor Dicey. He mentioned that a person has a discretionary power. There must be arbitrariness. I will not say the person is completely clean cheat, like 100%. Some maybe 0.005 loopholes is there. See, others will be always ready to pulling your leg. They are ready. They are just watching dog, like where you are doing some mistake and they will catch you. So if that judge is 99% clean cheat, but the 1% is something is there. So it's going to be a both. See, as a professor, as a law professor, I always going to be a balancing between the both the sides. I do agree that the judge is clean cheat, that is okay, everything, but some of the other thing, I say na 0.05, it will be the open door, and the open door will be your enemy will enter, and then they will get the chance to the going to be, when your journey for the your entire life, and you will get a chance for the end of your retirement, the door will be open to the others and the others will enter, the entire career will be spoiled. So as of now I could not mention any statement on this one, sir, because as a law professor I know there are so many things which is very sensitive part and which is directly uh, impact on the community. So I think this the thing is take us aside for this thing.
No, understandable. Yeah, that's fine. No worries. Yeah, thank you.
Mhm. Thank you, sir.
Thank you, Dr. Patil. Uh, I do have a question. However, before I move forward, I really want to give Satyanaji an opportunity to ask his follow-up question. If you can just do it real quick, we would
Mhm.
appreciate that. Satyanaji, are you still there? If you want to ask questions. Okay, I think he's not here. So yeah, I can ask my question. Um, Getting back to the topic, I know it's a comparative study, and I have done a comparative study, and I know there are like so many points where our biases comes, our own criticism, our own perception comes in place. I have a question for you. Like when conducting this comparative study between Indian Constitution and US Constitution, I wonder if you have done constructive criticism time to time, and if you can like if you I wonder yes, but if you have like any example. I know you have mentioned a few things in the conclusion, and while presenting, you have mentioned so many things. But if you have like a like one particular example about social justice or human right related issues that you have constructively criticized while doing this comparative study.
Yeah, I constructively criticize about this so many things. Like when I got appreciation from Justice Trudeau, Canada Prime Minister, he appreciated my comparative study, and even in Ken Paxton, which is a Trump legal advisor in Texas, he also visited last year. He also appreciated for the comparative study. But despite the everything, very frankly speaking, I came to know the India facing the caste problem for the discrimination of the caste. The same in USA is going to face for the racism. That is the one sentence. And this is a big drawback. Even you are doing a, you know, 24/7 study, hardworking, the everything. But end of the day, some of the other you will face the problem in US because of your racism.
Yeah, no, that's a good point.
And
Sorry.
to be very frankly, even in USA, Bill of Rights has provided absolute approach is there, harmonism is there, individual freedom is also there, judicial interpretation is also there. So many things are there, but one individual will be facing the problem because of racism. Immediately, nobody will support you. Immediately, I'm saying first aid, like first aid box. Immediately, nothing will be there. You have to face the problem, and gradually, it's going to be sort of. So that is a big loopholes which I came to know in USA when I visited in USA this year only, when United Nations headquarters invited me as a guest. So which I this is the one sentence in your question, Ranjit.
That does make sense because when we talk about
Yeah.
these two big issues from two countries,
Hmm.
and these
Hmm.
two issues are deeply rooted in the both the societies, and it will definitely take time. Like, we see
Yeah.
people come in place, we see there
Even
are
for the job.
organizations
Yeah.
who,
Even for the
trying
job
to,
appointments.
yes.
Hmm.
So that does make sense. Satyanaji, we can definitely take your last question if you can do it real quick. Uh, and if you're not able to do that, that's absolutely fine because I have questions, so I can go ahead if you don't have.
Yeah, well, I just wanted to again state that who is appointed as a judge is of almost as important as what's written in any of the law books. With their personal moorings, personal, political, cultural, biases are extremely important. So I don't know how to make that those appointments um, more fair and more fair.
Uh, yes. Judges are a very simple things are judges are also human beings, and if a judge faces personal losses like mooring, so they can take a leave for a few days. The court may adjourn that judges case temporary. Judges judicially duties can be resigned to another judges until they return, and there are so many things. But personal mooring is respected, and judges can take time off like any other human being.
Okay, thank you.
Thank you, sir.
Great, great. Amazing session. Thank you, Dr. Patil. It was amazing.
Thank you
Very
so much for
in-depth,
me.
yeah, very thoughtful, and at the same time, very important. Um, Again, just to conclude the session, thank you so much, Dr. Patil,
Thank
for
you
being
so much.
here, for giving us this much needed information. Thanks to your team as
If
well.
I may, if I may
Thank you.
just one thing. What does she? I forget her name. What do you think is the best way of appointing judges? I have no clue in my head, but I'm asking you.
I think
As
that's
per law
out of
and
the
order, it is the
competitive.
procedure one. As per law and order, it is the procedure, appointment of judges. But yeah, it's a big issue for the appointment of judges and transfer of judges, because if the case is sensitive before the court and the court wanted to not I do respect to the all dignitaries and the high politician actors in India, but in like Shah Rukh Khan's son, which was the recent, I mean, everyone aware of that one. So if the case is pending before the court and the authority, and suddenly the officers are going to be transferred to one place to the another, so it's a big question for the normal people. How can the normal people will survive? If instead of Shah Rukh Khan's son, if like my son will be there, then who will going to support? Nothing, no one. So I mean, it's still big question.
No, often judges are moved from the bench that is considering a course. So that's of course, interference in that.
Mhm.
Appointing judges to High Court and Supreme Court, uh, even here as well as there. Here, of course, it's all totally political. Seems like I mean, the president appoints whoever he wants to the federal courts, higher courts, and and to the Supreme Court, of course. And in India, it's the so far it's being done by the judicial what do you call you know.
Satyanath, sorry to interrupt. I do appreciate your thoughtfulness. However, it's 12:32, and I really want to
Yeah,
be.
why don't you let her answer and we finish?
Yeah, I was coming to that. I was coming to that point. I wonder if Dr. Patil has understood your
What
question.
was
So
that
I'm gonna,
question?
yeah.
How do you think, what can be the right way of appointing judges, particularly to the Supreme Court?
See, Satyanath sir, as per the procedure wise, it is for the authority who is going to appoint it. But if you said my personal opinion, my opinion must be the thing like anybody randomly who had expert in that field can be a dais who can appoint the judge. I mean, if the 10 high courts 10 high court judges in across state, you can randomly select 2 3 judges, and that 3 judges will be selected the Supreme Court judges. The randomly I'm asking this, I'm giving the answer. But in the Supreme Court, already procedure has been mentioned in the document, and so that Supreme Court has to follow the procedure for the appointment of Supreme Court judges.
Yeah, but I was basically asking you, if you were the authority, if you made the convention, would you think, irrespective of
I
done?
Yeah. So in my opinion, if I am the authority, I selected the person who has caliber, who has not create any kind of discrimination, not I get any kind of influence. I would like to share my personal opinion as a professor in this field. I got a call one of the High Court registrar. I mean, I could not mention that name. I got a call of that High Court registrar that he say you can be complete my work right away. That date was last date. I say, your date is over. You have to come and meet me in the month of June. You came and meet me in the month of September. I requested you, you can come and submit your all the procedure in the end of September. Despite that, you are coming in the month of December, in the month of November first week. I would not handle the case. You can please leave. What that fellow did, I got a n number of call. I got n number of messages on my WhatsApp that please accepted that person's so and so case. When I got a last call, entire day I was try to suffering for the harassment that I got n number of messages for the even the minister's PA all calling me that madam please help him out and all this stuff. When the last call I get it for that fellow, another one, not that person. What I requested that man, please convey my message to the Register of High Court that if I get any kind of message or the call on my number, I immediately rush to the police station and file a complaint about the harassment. So on that moment, then he stopped. So I am as a professor, I completely not create any kind of discrimination. I don't like at all, sir. This is my principle. My principle is like whatever you are showing me, please you can show. I can help you out. Being a professor, I am ready to help out everyone. But if I get influenced by so and so, if you have influence, okay, fine. I accepted your influence. Put it your written application. Nobody is ready. This 21st century, they give you references on written basics that yeah, these are the influence. Please help him out and all this stuff. So being I am authority to selection of Supreme Court judge, I'm not interested to any kind of create bias and the discrimination thing. I'm very clear for that.
Okay, thank you.
Thank you so much.
Thank you, Satyanathji. Okay, now we can conclude it.
Yeah.
Thank you, Dr. Patil.
It's 11, yeah.
Yeah, I have mentioned things and I'm again mentioning it. It was really, really important. Thanks to Samruddhi for sharing your slides, which was, which was the critical part. And thanks to your team. Also, we didn't have
Okay.
Banteji today, but he's a great resource for teaching about Dhamma. And we had Mihit Wamankar today for presenting with Kid Story. Thank you everyone for attending the Vihara today, and have a good night, Dr. Patil and your team.
Yeah.
Have a good rest of your
Good
day.
morning and have a
Yeah.
great day, Pranit, and the entire team in the US because it's the morning there in the Sunday. Have a wonderful Sunday to all of you guys.
Thank
So,
you. Thank you.
yeah. So, may I
Have a
leave
good
now?
night. Yeah. All right.
Yeah.
Thank you.
Thank you so
Bye-bye.
much. Yeah. Bye bye. Yeah. Bye.